So I am going to be speaking about how copyright can and does affect the creative industry using copyright policy. Now, I realize that Professor Sihanya has given a number of points about copyright policy in Kenya, and I will be making an extension of his presentation, so to speak, making a few comments on open scholarship as well, which is also his area of research in this project. So, to start with, and to introduce, I will say that to look at copyright policy interaction with the creative industry, to me would involve, okay, let me take one step back and say how I intend to go about this presentation. I'll start by looking at how the two interact, that is government policy in terms of copyright and the creative industry. I will proceed to look at the expression of government policy in terms of legislation, and then I will also look at its expression in terms of judicial decisions, a few here and there, and of course noting the points that Professor Sihanya made about judicial decisions being open to debate. And then thirdly, I will look at other jurisdictions, specifically the UK, and what it is their ideas are with regard to copyright policy and whether or not this could fit in our environment. So, to go back to where I was, how copyright policy interacts with the creative industry. I look at the interest here of the two bodies, or the two parties involved. The government, on the one hand, is interested in giving its citizens, part of whom are the creatives, an opportunity to be able to make an income, and also a little bit offload its burden on having to provide employment, which many of us look to the government to do. What do the creatives want from this equation? The creatives want to be able to make an income. They want to either be employed or they want to employ themselves, to be self-employed. So you can see that from both sides of the divide, there is a question of income, that one side wants to facilitate the making of income, and the other wants to be able to benefit from the income. And so copyright in this context comes about from the idea that we've had from the various presenters here today, that incentivization is the idea behind having a copyright policy, that whoever is able to come up with material that is original should be able to benefit from it commercially. And so it is that if we look at the Kenyan context, how does Kenyan copyright policy make it possible for the artist, for the musician, for whoever else is engaged in creative endeavor that is protected by copyright? How does the government have policy in terms of, that is expressed in terms of legislation that enables the artists and all those creatives to be able to make an income? First of all, and through the Kenya Copyright Board, I refer once again to Maricela, relatively low registration fees. So it is the case that for about 1,000 shillings, if I remember well, you can be able to get copyright registered. And here I'll step back a little and note that it's not necessary for you to register copyright. Copyright begins to exist once you express your original idea in material form. That becomes automatically it bestows upon you the ownership of the copyright in that work. However, it is important for you to be able to register it for the reason that should you want to enforce that right in future, if someone else is overstepping their boundary and using what is rightfully yours, you would want to be able to prove it. And by creating a forum through which you can receive a registration certificate that says that you're the owner of the copyright in that work, then the Kenya Copyright Board, through the Kenya Copyright Board, enables you to be able to assert that right in future. So that's one way in which government policy that we have works to the benefit of the creatives. Secondly, we have a relatively short registration period. I have assisted clients in registering copyright, and I can say with authority that it took us 7 days to be able to register that copyright. Long or short, depending on your speed, of course, and your needs, but to me, I would say that's a rather short time, given that maybe other registries would take a little bit longer. And that might have something to do with the nature of the work that is registered and maybe the volume of work that they have, but be that as it may be, there is a short registration period that enables creatives to be able to get that registration certificate, which we have found to be important within a relatively short period of time. And then there are remedies for infringement. We'll be looking at that case law once again to, actually I'm not sure I have a case here that talks about, that gives a situation where remedies have been given, but the Act does provide a way through which you can be able to access remedies, be they civil remedies or be they remedies that you receive from a criminal proceeding. From a civil remedy perspective, you'd be able to get damages, depending on, of course, what your advocate has asked the court for. You'd be able to access damages, you'd be able to get an account of profits, you'd be able to get an injunction issued by the court. On the other hand, if you have criminal remedies and the court finds you guilty of having infringed someone else's work, then you'd be liable for imprisonment or a penalty in the form of a fine. All of these are set out in our Copyright Act. Now, if you look at Vision 2030, narrowing down specifically to our general policy blueprint as Kenyans, Vision 2030 talks about copyright in a sentence or two. And it talks about enabling young Kenyans be able to obtain an income from their creative endeavors that are protectable by copyright. And it goes on to mention that it would be useful also for purposes of encouraging foreign investment by having copyright. So you can see there that the government has an overt statement about protection of copyright and where this would fall into its whole economic ideas. There is also the term of protection that is accorded by the Copyright Act. You'll find that for literary works, for artistic works excluding photographs, the general period of protection granted is 50 years after the death of the author, including, of course, the life of the author. Now, just going back to the TRIPS agreements that Professor Sihanya had spoken about, that's the minimum required term for protection of copyright. So the government has sort of taken this minimum term as the term that Kenya uses. You'll find that in other jurisdictions, that period of time is 70 years or so. And by providing a relatively short period of time for copyright protection, it means that within a shorter period, here looking at 20 years, if you're comparing with a jurisdiction where they have 70 years of protection, where you'd have the work falling into the public domain within a shorter period of time, and therefore being accessible for people to be able to work on that material, either by modifying it or working on it in whichever other manner would enable creative endeavor. Other people would probably argue that even that period by itself is too long, 50 years, including the life of the author, but that's what we have, and I think we've used that as best as we can with the current circumstances. And then the Kenya Copyright Board is also engaged in public awareness campaigns. We've talked about awareness in this forum as being particularly important for purposes of the public being aware of the rights that they have when it comes to copyright, in terms of enforcing their rights and just generally benefiting economically from their work. So the government policy through the Copyright Act that we briefly looked at provides those opportunities for creatives to be able to benefit from our copyright law. What can creatives do in order to ensure that they get to benefit from the law as it currently stands. Firstly would be timely application for registration. Now, here I have listed a case that is reported, and it's the case of Margaret Suarez and another versus Simon Kimani Njau, trading as Bombers Interior Designs, and 3 others. Case reported in 2010. Now, the facts of this case were that the defendants, or 3 of the defendants, I talk about, or it's quoted as others in that case, the defendants had been employed by the plaintiff, and what happened is that eventually they set out on their own, and they got together with someone who had been a customer of at the place where they previously worked, and the business that they were engaged in, working for that employer, was in the sculpting of garden ornaments and pottery, which are eligible for copyright protection. But the thing is, during the period of their employment, they did not, or their employer did not apply for copyright registration. And so it was that shortly after they left that employment, they set out on their own and started to make copyright that the plaintiff thought looked suspiciously similar to hers and the enterprise that she had set up. And so she sought a legal remedy from the court, and it turned out from the evidence that was looked at by the court that that copyright registration had taken place just shortly before the suit had been instituted. And so it left some uncertainty as to whether that copyright was actually held or she was actually the owner of that copyright, which made her eventually, or which formed the basis of the decision by the court to not allow her, or to not grant her the remedies that she had sought for infringement of copyright. It became difficult to prove. Bringing into play once again the point that I had mentioned earlier of importance of registration. Had that copyright been registered earlier, probably the outcome would have been different. The second point would be taking legal action when rights are infringed. Now, one of the creatives here, a lady had mentioned earlier that the legal process, or the process of having a suit heard in court is intensive in many ways. Whether you're talking about economically or time-wise, it's intensive in many ways. But if it is possible, it is the case that courts have enforced rights that are available to copyright owners. And one of the cases that demonstrates this is the case of Mary Kukali versus Mary Ogola and another. What had happened in this case was that the plaintiff instituted a suit on the basis that the defendant had used some of their material from a dissertation to write her own dissertation. And the court, having examined all the material, found it to be the case that the material that had been used to write the defendant's dissertation had been derived from the plaintiff's dissertation, and went on to grant an injunction against having that dissertation published. So depending on whether or not you agree with the thinking behind that case, the point is sometimes the courts do grant injunctions for copyright infringement. Then thirdly, taking legal action within the time allowed by the law. It is the case under our Limitation of Actions Act that you need to be able to institute a suit within a certain period of time of whatever it is that you're complaining of had taken place. Now, in terms of contract, you have a limitation period of 6 years, and in copyright, the one authority that I've looked at, or the one case that I've looked at, talks about 3 years on the basis that the action that was being complained of falls under the category of torts, and it was the basis upon which the plaintiff in this case failed in their application to have the defendant be found or to have damages awarded to them on the basis that their copyright had been infringed. That course of action, that suit got instituted after 3 years were up, and so the court found that it could not hear the case. So those are pointers, and I talked about that before. The exceptions are to the ownership of copyright, or exceptions granted to copyright to non-owners of copyright in terms of being able to use copyright works had been mentioned by Professor Sihanya, and just to rehash them, there's use of the work for research or review or criticism. Private use is also allowed, education and reporting. So in this manner, and just to go back to my earlier point, the government takes cognizance of the fact that every now and then it will be necessary for people who do not own copyright to be able to benefit from work that is protected, and to be able to build upon those ideas and be able to come up with other works. Now, in terms of enforcement, Section 26 of the Copyright Act talks about whatever remedies will be available, talks about civil remedies and criminal remedies, and that section talks about them in quite a bit of detail. Now, in terms of reform, the digital era has been discussed at length in the course of the many presentations that have taken place today. And to go back to the aspect of digitization, which certainly makes it easy for copies to be very quickly made and distributed with an ease that did not exist before, it would be important for the government or for legislators, policymakers, to take into account the digitization and the various peculiarities that surround it in coming up with laws that would enable copyright holders to get protection. Of course, looking at this from the creative's perspective, as I am, means that I tend to lean more in this particular presentation towards protection of their rights. But I would also like to mention that it would be useful in the terms of that policy making to also look at the manner in which concepts like acknowledging authorship or authorship in the copyright context would take place in a digital environment. There is the idea that has been proposed in the UK in a 2011 report that had the idea of having a digital copyright exchange, whereby there would be an exchange sort of, when I conceptualized it, I thought about a securities exchange, just without, and the sort of trading that takes place, and having a system and all these very technologically advanced ways that enables one to be able to tell that their material has been used to enable payment when that is necessary, and to be able to just basically track how that work is used. Whether or not that idea would work here is a question that can be determined later, but be that as it may be, digitization is real and it needs to be accommodated. Even as we continue to make laws, we continue to amend our laws to be able to fit into the digital context. And then also, there is the East African community, which is becoming a growing reality. And for that reason, it would be a good idea to harmonize as far as possible the laws that are in the region in order to make trading easier. It would be important to have laws that are largely similar within the region to enable enforcement and to enable a sense of clarity within the region. The thing is, with regard to intellectual property, a lot has focused on patents, and this certainly has been important because of the human rights issues surrounding whether access to medicines, but also in terms of copyright laws, it would be important, given that such a large number of people depend on copyright for their daily bread, to be able to make that daily bread accessible to them, and also be able to make those who are up and coming be able to have their materials used in a manner, to be able to use materials in a manner that will benefit them and will also benefit other generations. That marks the end of my presentation. Thank you.